Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title or ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In the show tonight, we will learn the nuts and bolts involved in probating an estate in the state of Georgia. We will also review the role of the Georgia Probate Court throughout your probate train ride, from the time you legally qualified to act to when you wrap up the estate and distribute all the assets to the beneficiaries. And we will highlight important duties and deadlines to keep in mind during the course of your journey. With us tonight is a Georgia attorney who will share his expertise and guidance on this topic. Our guest is the founding partner of Curtin Law Firm, a boutique estate planning and administration law firm in Atlanta, Georgia. In addition, he serves as a court-appointed attorney for proposed wards in adult guardianship and conservatorship matters, and as a guardian ad litem in contested estate administration and guardianships. He is a past chair of the estate planning and probate section of the Atlanta Bar Association, and he has been a presenter to attorneys in Georgia bar CLEs and to financial advisor groups in the areas of estate planning and probate administration. Please welcome Atlanta, Georgia attorney Tim Curtin. Hi, Tim.
Hi, Richard. Thanks for having me.
Oh, welcome. Thank you for coming and taking some time to talk to us. Let's just go sort of get started here. Tell us what court actually oversees probates in Georgia.
Well, that's a very easy question, Richard. We have 159 counties in Georgia, and we have 159 probate courts.
Oh my goodness gracious. Oh my goodness. So how is the probate court involved after the probate has been initiated? So tell us a little bit about that.
The probate can't get initiated until the probate court gets involved. And the probate is initiated when somebody, either an executor or administrator, we'll talk about that in a few minutes, goes to the court or mails to the court paperwork to ask to be appointed. And at that point, the probate process has begun.
Okay. So again, we're going to start in the beginning and talk about the end. How is the probate court involved in wrapping up the estate?
In wrapping up the estate at the back end, the person who was placed in charge needs to ask the court to be discharged. And they file paperwork with the court requesting a discharge. And if the paperwork is in order, then they receive their discharge and the probate is closed.
Okay. Now, when we were preparing for this particular program, we talked about that many of the filings that someone would submit to the probate court are done on court-approved forms. Can you share your thoughts on the advantages and disadvantages of these forms?
Everyone, either attorneys filing the forms or people representing themselves in the probate court filing the forms, should use the standard forms if a standard form is available. The court prefers it. There are actually requirements that you have to follow that if you choose not to use the standard forms. So all in all, attorney or individual doing it for yourself, the probate standard forms are the way to go.
Okay. Okay, so it's important for folks to recognize that Georgia seems to have organized these things to make it as efficient as possible. So, and very, very consumer friendly. So let's talk about the probate of a will. Okay, let's begin with, if there is a will and it's in a safety deposit box, how do we get that?
That is unfortunately a far too common issue. There is a probate form for that, Richard.
And you would expect there to be one, right?
Yes, of course. And you file a petition with the court, a form with the court, asking for permission to have the safe deposit box drilled.
Okay, and then you basically can draw out the will and bring it over to the courthouse, I guess. So, so let's talk about if there is a will, we've got the will, what are the various options available to probate a will in Georgia? So let's just start with, if the will has a self-proving affidavit, tell us what that affidavit's about and how we go about starting probate with that type of will.
Sure. So the basic requirements of a will in Georgia is that we have two witnesses, and that is a valid will. One step better is to have a will with a self-proving affidavit. And all that is an affidavit affixed to the back of the will that is notarized by a notary that says that the testator, the creator of the will, said that he or she created the will, and the two witnesses were present at the signing of the will. And if the notary affixes his or her notarial seal to that, then it becomes a self-proving affidavit. What that means, Richard, is you don't have to track down the witnesses when it's time to probate the will.
Well, that's very important because sometimes those witnesses could have disappeared or maybe they passed away as well. So that is an important thing to do. So how do you then initiate the probate of a will that has a self-proving affidavit?
There is a form for that, and there is a petition to probate in solemn form, and the petition is 4 pages long, and you complete the information in it, and you file that along with the original will with the court.
And do you have to file an original death certificate too?
Interestingly enough, now I'll go back to what I said earlier. We have 159 probate courts, so every court does it a little bit differently, but most metro Atlanta courts do not require a death certificate simply because down here, it can take 6 or 8 weeks to get a death certificate issued, and the courts have decided that they will rely on the oath of the executor that the decedent is actually deceased.
Okay, that's very interesting. All right, so let's just say that the will does not have a self-proving affidavit attached to it. So what do we have to do at that point then in order to get that will admitted to probate?
In addition to the petition, you have to attempt to locate one of the two witnesses, and there is another standard form, and that standard form is called an interrogatory or interrogatories. Mm-hmm. And the witness needs to complete a one-page set of questions that the witness did, was present, saw the testator sign the will, a few more items that those interrogatories need to be sworn to before a notary public and filed with the court, preferably at the time the petition is filed.
And if you can't find one of those witnesses, then what would you then have to go to court to prove it?
Then it's anyone's guess. We file an affidavit of diligent search that we attempted to find the witnesses, and then the ball is in the probate court's court to determine whether or not we were diligent, and is there anything else we should have tried to do? Is the court satisfied? To your point, Richard, some wills that come into the office are 20 years old, and, sure, and the witnesses have passed away or retired and can just never be found.
Of course, of course. Well, let's turn to the next page of this particular story. So we talk about there's no will, and then we're talking about the probate of an intestate estate. So what does intestate mean?
Exactly what you said. Intestate, an intestacy is where there is no will. And I like to go a step further and say, if you don't have a will in Georgia, the state of Georgia has drawn your will for you, and that is an intestacy.
That is so true. And that is, of course, people a lot of times don't realize that, which is why it's important to be able to have those witnesses and to do the self-proving affidavit from the very get-go, if you do a will. Now, how are the heirs determined on an intestate estate?
There is an heirs determination worksheet that most courts use, and it's simply looking at your family tree and finding the people who are your closest relatives, being a spouse and children, are in the first degree, and then you move out from there. Parents come after that, siblings come after that. Then you branch out to aunts and uncles, and you're required to notice the closest set of relatives. Okay. So if you have a spouse or you have children, you stop there. If you don't, you move on.
Okay. Now, so if there is no will, then how is this intestate estate administration initiated with your probate court?
Not all that differently from a petition to probate a will. You
Okay.
have another standard form, and it just has a different name. It's called a petition for letters of administration.
Okay.
So if we have a will, we typically have an executor. If we don't have a will, we have an administrator who essentially carries out the same functions as an executor.
Okay. So let's talk about, we started to talk about the identification of both heirs at law as well as beneficiaries if there happens to be a will. So tell us what the difference is between an heir and a beneficiary.
That's a great question and often misunderstood. When you have a will, that's the only time that's the time where you have named beneficiaries in the will. The will set forth who's going to receive the probate assets and in what amounts. Heirs are the people who would have inherited if there was no will. So going back to parents and children in the first degree, parents in the second degree. So a lot of times the beneficiaries and the heirs are the same people, but not always.
So when you're starting an administration, I know you talked about you have to give notice to people and so on. So you would give notices to both heirs at law and beneficiaries? Is that how that normally works?
When you have a will, the legal requirement is at the front end that you only give notification to the heirs at law. It's essentially a legal safeguard to see if the people who would have otherwise inherited, if there was no will, have any reason to believe that the will's invalid.
Okay.
Beneficiaries don't need to be notified until the executor is seeking to be discharged. And the beneficiaries will essentially say, yes, I received what I was supposed to receive under the will. I agree the executor can be discharged at this point.
Okay. So if we, I guess in Georgia, it's important to be able to locate or at least give notice to heirs and beneficiaries. If you can't find them, let's say, what's the best way to find these types of people, at least initially? I know we've talked a little bit about that when we prepared for this program. How would you start to find those type of people? So
thankfully, most of the time, there's usually one person identifiable. Whether it's through the will, whether it's through going through decedent's personal property, just a little investigative work to see if we can find anybody who is close enough to the decedent. It could be a friend, and that friend knows relatives, and anything to get the ball rolling.
Sure.
Surprisingly, Google is an excellent start. And if that fails, if the family member's friends can't help you out, if Google can't help you out, there are companies out there we call HEIR, H-E-I-R, HEIR search firms who will research records and try to locate these people for you.
Okay. So you have a bunch of people, but there's a bunch of resources. You try to start the simplest stuff first, and then if you have to go, you can spend some money to have formally investigated. So now we've got somebody qualified, whether they're the intestate estate or an estate with administering a will. Let's talk a little bit. What are some of the more important duties that a personal representative who's been appointed by the court? What are some of their most important duties that they have?
So at the outset, it is vitally important that the executor or administrator creates a complete inventory to the best of their ability of the decedent's estate. Right behind that becomes identification of creditors, because the executor does have a fiduciary responsibility to creditors. The executor is required to post a notice in what we call the legal organ, the county newspaper, announcing the establishment of the probate and that any creditors should file a claim. We have the standard housekeeping things. Is there a mortgage that needs to be paid? Are there car payments that need to be made? We need to open up an account for the estate, a separate bank account. We need to get a tax identification number for the estate. So there's many things, and we always keep a checklist for that to make sure we've at least identified the issue and see whether or not it needs to be, any action needs to be taken.
And certainly clearing your any tax obligations is an important thing for folks to take care of as well, especially with the IRS. I'm not sure about the Georgia tax authorities, but certainly the IRS likes to be paid, and they like you to settle up with them before they let you go, so so to speak.
Yes.
So tell me, does a personal representative have to, you talked about filing an inventory, okay? So everybody has to file an inventory, I gather, no matter what. How about an accounting? Do they have to account for everything they receive and disperse after that?
There's a lot of flexibility with that in the law. The default is that an executor does have to file an inventory, has to file annual returns, has to file a final return. But all of that can be waived. And that is very frequently done in the wills, where any requirements to file reports with the courts are waived. We're not relieving the executor of the obligation to make reports to beneficiaries, but anything that's filed in the probate court with respect to an estate is a public record. So
Okay.
that is not something most people want to have published for anybody who wants to see what a decedent owned at the time of his death.
Sure, of course, that makes sense. So, so you say that even though you're not filing with the court, the personal representative still needs to keep the beneficiaries informed about what they're receiving, what they're dispersing.
Yes.
Okay. Now, are there any probate timelines or deadlines to be concerned with when you're handling Georgia probate?
The law is very vague on that. A will must be filed even if it's not going to be admitted to probate. The law requires that a will be filed in the probate court within a reasonable amount of time. But that definition of reasonable amount of time has never really been established. So I have filed, I've opened probates for decedents who passed 10 years ago.
Okay.
So there's no type of what we might call a statute of limitations on that. It's usually more of a practical issue. If somebody's not in control of these assets, they tend to go away. I believe in Georgia, the property for, let's say in a bank account, can be paid into unclaimed funds after 5 years of inactivity. Typically, that doesn't happen. Typically, there is somebody who, and usually a beneficiary under a will or an heir at law, who is willing to take over that in order to receive their inheritance.
Okay. Well, let's talk about, we talked about assets, let's talk a little bit about liabilities and really creditors. Okay, so, I'm not reporting to the court, but I have an obligation to do something with these creditors. I guess I have to settle up bills. So is there any way that I have to inform creditors, or how I can inform them if I don't even know who they are, that I have an estate, and if you have a bill, send me your bill?
There is a requirement at the outset that you publish a notice for 4 weeks in the county organ. And there is also a requirement of diligence on the part of the executor. And that meaning they can't just stick their head in the sand and not do any type of reasonable inquiry. You have to look at what comes in the mail. Are there bills that are coming in the mail? If you have access to the decedent's emails, are they receiving email statements? And you can look at perhaps tax returns, see if there's liabilities there. The executor must be diligent in trying to actively seek out the creditors of the estate.
Okay, well, that makes sense. And of course, you mentioned it's an important thing, I guess, early on, is that the executor or administrator should go to the post office and do a mail forwarding so they can begin to see that mail. And that'll be a rich resource of information for them. So that's the importance of the notice. So what happens if a claim is filed? Let's just say do the creditors file a claim with the court if they don't get any response from you, or anything like that happen in Georgia?
Yes, the creditor files a claim in the probate court in the particular probate case and makes notification of that claim. And then it's up to the executor to validate the claim. And if the claim is valid, before any distributions can be made to beneficiaries, the creditors have to be paid.
Okay. And of course, I assume that if you were, as we talk about wrapping up the estate, you can't undertake to wrap the estate up, but that claim is still marked as having not been paid.
Exactly. Whenever you pay a creditor's claim, you have the creditor sign a satisfaction, which is then filed with the court as well. And then when the court is reviewing the paperwork for the discharge, they're going to make sure that there is a satisfaction of every claim that was filed.
Okay. All right, let's talk about the end of the train ride here, as we call the probate train ride, which is we're wrapping up the estate. So how is an estate closed?
That is through the standard form called the petition for discharge.
There you go again, talking about standard forms.
Yeah, it does it makes life easy in the probate context.
So you file something with the court indicating that you want to wrap the estate up?
You are telling the court that you have fully administered the estate, that all claims have been paid, all beneficiaries have been paid, and the court's just not going to believe you. They're going to want to see the satisfactions from the creditors, and they're also going to want to receive either a signed consent from the beneficiary, that the beneficiary has received everything that they are due, or if a beneficiary fails or refuses to sign the consent, then the court will serve the beneficiary with notice that the executor is seeking to be discharged.
Okay.
And give them an opportunity to object.
Okay, so it sounds like a nicely controlled process. Now, what is the typical time from beginning to end for a normal estate to be probated in Georgia?
An executor can get discharged 6 months after appointment. It usually takes closer to 12 to 18 months, simply because, as you touched on, Richard, you have to file that final tax return. You want to make sure you're not seeking a discharge. You don't want to pay any beneficiaries before you're sure there's going to be no tax liabilities. So although a lot of people like to get it done quickly, they like to get that burden off their shoulders, my general advice is to take your time. Just make sure you as the executor have insulated yourself, make sure you've done everything properly before you seek that discharge.
And I would think you pointed out something very important. It's it takes a long time for the IRS to respond to your request for discharge. So it could take you a year and a half just to get them to give you the discharge that you might be looking for. Well, we're running a little bit short on time now, so I want to ask you for some final words of advice on steps to take, pitfalls to avoid, anything you want to emphasize in connection with probating an estate in Georgia.
I would say 3 things. Be organized. Make sure you are keeping a very, very close tabs on what the estate has, what the estate owes, who are the beneficiaries. Be diligent. If a house needs to be sold, meet with the realtor, get your appraisal, keep the ball moving. It is amazing how quickly a year can pass by and then nothing's been done and you're getting yelled at by beneficiaries. And finally, and probably most importantly, is transparency, is keep your beneficiaries involved in the process. Let them know what you're doing. Let them know what you're receiving, what you're paying out. I always tell my executors, just paper the beneficiaries, just give everything that you do complete transparency, because that's when I find most of the problems arise are not because executors are doing something wrong, but because they're not being transparent.
Those are very wise words of advice for any of your clients like that. Tim, on behalf of the Probate Nation, I want to thank you, for taking the time to visit the Probate Nation all the way from Atlanta, Georgia, and for sharing with us both an overview of the Georgia probate law, as well as your advice as to what to do and not to do. Valuable information and a great public service for those viewers confronted with a Georgia estate to be probated. Thank you again, Tim.
Thanks, Richard. It was great being here.
Without a doubt, folks, probate can be complicated and confusing, and in this show, our guest has given us an excellent introduction to the Georgia probate process. Be sure to also check out all of the useful guides, forms, and checklists available online from the probate courts in Georgia, including the Fulton County Probate Court website. Collectively, these resources and the insights shared by our guests this evening should make your Georgia probate train ride go a bit more smoothly. But I would be remiss if I did not emphasize the importance of consulting with a local Georgia attorney about any probate you may need to initiate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed, while shortening the time you ride that Georgia probate train. This brings us to the conclusion of our show. I hope you found the show helpful should you probate a Georgia estate. And remember that replays of this show and all the shows today can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.